from the University of Northumbria, UK, and possesses a Master of Laws degree from the University of Edinburgh, which he graduated with a distinction. Mr. Ashok Baran regularly contributes to various legal journals, and he was a co-author of the chapter on Sri Lanka in the Global Review of Constitutional Law in 2018 and 2019. I also warmly welcome Mr. N.K. Ashok Baran for today's session, and without any further ado, I invite him to commence today's proceedings.
Thank you, Suvi. Good evening to all viewers and good evening to our esteemed panelists, Mr. Adjudicating. So today we are going to discuss a very important, significant topic in constitutional law as well as everyday life of our citizenry, that is fundamental rights. So Devendra, without further ado or decorative flowery words, I want to get to the point. Fundamental rights. Well, we usually hear the term human rights, but fundamental rights is a little bit different from that. And it is guaranteed by our constitution. Since this is basics of law, it would be appropriate for the discussion to commence with the scope of fundamental rights and how it came about into our constitution. A short reconnaissance to the history of fundamental rights being part of our constitution would be a good point to start. I think you're muted.
Thanks, Isuri. Thanks, Ashok, for the introduction. Uh, 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 Fundamental rights. Now, you hit a very important point. That was what you said, the term human rights. Now, human rights. Let's not get into the history of human rights. It will start from the UN Charter and so on and so forth. Let's not get into that because we are looking at the basics of it. But human rights are basically what a human should be assured of, irrespective of whether there are laws, whether you are conquered by another country. This human rights charter, the charters and the UN all comes in after the Second World War, because you know about the genocides, you know about what happened to the Jews. So it comes after that. So the basic things that any country, any law should secure becomes human right. And what our constitution has done is that selected certain some of them and said that these are fundamental rights and assured them, and says that that has to be secured by all organs of the state. So those are fundamental rights which are secured by our constitution.
So if you look at the history, one might see the fundamental rights chapter came about in the what we call the first Republican Constitution, the 1972 Constitution. However, commonly we are generally in law colleges and Sri Lankan law universities, we are taught that justiciability of fundamental rights was introduced in the 1978 Constitution. Ergo comes the Article 17 and Article 126. We wish to hear the scope and nature of this justiciability and the how a fundamental rights application is made to the Supreme Court under the present constitution.
Yeah, Ashok, before I get to your question,
Yes.
The fact that in the 1978 Constitution, that was the first time that in Sri Lanka the concept of fundamental rights was recognized.
Yes.
Right now, even in this present context, we have certain fundamental rights which are recognized, which are not justiciable. That is to say that you can't go to court and say implement this. For example, economic rights, you can't. But in the 1972 Constitution, it was there. And actually, I have heard, even though I was not, I was born with the new Constitution coming into play,
Oh.
you and Isuri would have been much after, but that the right was there. That was to say, look, this is what the organs of the state must do. That is The judiciary, executive, administration, the legislature, they must follow this, right? So with the new 1978 constitution with Article 17 and 126, they gave a pathway and said, look, if this is violated, infringed, you can go to, and then they set the forum. Because I am told those days, when this 1972 constitution, when it came into play, when these were recognized, some people, in fact, went to the district court and said, my fundamental rights are violated because there is no forum dictator. But with the 1978 constitution, they not only said that these are the rights that you have, with Article 17 and Article 126, said, okay, you can go to the Supreme Court within month of the infringement, right, by yourself or by an attorney at law. So it was frameworked in such a way that you were given a jurisdiction and you were given certain parameters.
Yes, so I think we have come to the very contentious topic of this 1 month, which you correctly mentioned. It is always very confusing for young practitioners. This time bar objection, it's always raised by the respondents, mostly so you have to come within 1 month. There is, of course, one recognized exemption, that is the human making a complaint to the Human Rights Commission. However, we see mere complaint is not enough. So now my question at this juncture is, what does this 1 month mean in the Constitution? How it is calculated? And what are the recognized exemptions? And as a practitioner, how one should advise their client on this time bar matter?
Now, let's not, without going to the complications of it, what the Constitution says is that you have to come to court within 1 month. That is one calendar month, right? So if you're, for example, if your rights are infringed on the 1st of January, you can go to court on the 1st of February. So you have 31 days, right? So, but if your rights are violated, you're claiming that your rights are violated on the 1st of February, you have to go to court by the 1st of March. That is 28 days. Not 31 days, not 30 days. Don't get confused. So it's calendar month, right? The opposing day on the next month. That is that. Before I come to the HRC thing, the law has developed in different ways. Now, for example, if let's say if you are assaulted, that's a one-time act. You are assaulted on such and such a day, so you have to go. Let's say you are assaulted on the 2nd of January or whatever day, 2nd of February, you have to go before court, right? But let's say you were assaulted by the police on the 2nd of February, but you were incarcerated for another 14 days, right? You come out on the 16th of February. There is judgments to say that even though you might have access to lawyers, but you don't have free access. You can count those days from the 16th, not from the first second, because you didn't have free, because from the 2nd to the 16th, you were just trying to get out. It is from the 16th only that you have the free access, where you can access lawyers, when you can file cases. So that is one thing, right? And the second thing, now, if you're complaining of an action, your Ashok knows this. If it's an action, no, it can be an inaction. If it's an action, you know when the action happens. If it's an inaction, you are asking for a promotion, you are asking for this thing. But there is a very good judgment of Justice Prasanna Jayawardena, late Prasanna Jayawardena, who says this. No, as long as that inaction is in existence, because there is no specific denial, the infringement continues. until such time you say, look, I'm not going to give you the promotion. I'm not going to do this. Right? You continue. So that is what we call continuous infringement. And there is also imminent infringement that does the time bar issue that you talk doesn't apply to imminent infringement. Then to the question that you ask, Ashok, that is the HRC. Now, Section 13 of the Human Rights Commission Act says that when you make a appeal, uh, that is the side note says computation of time for the purpose of Article 128 of the Constitution. And when you uh, make when you lodge a complaint to the Human Rights Commission, the computation of time ceases. So if you just take the basics of it, that says, okay, fine. I so let's say the infringement happens on the 1st of January. It's very easier when you put context into it. And on the 15th of January, you lodge a complaint to the HRC. So then the time ceases. That is what the Act says. So the HRC, the investigation or inquiry is pending. And on the, let's say, 15th of March, they give a decision either way, right? From that day, the time starts. So by the 1st of April or the 31st of April, your time has run out. You have to decide what to do. That was the basic idea. And I think I know where Ashok is coming from. Initially, when this happened, what the judges, the court was saying, okay, HRC complaint, we filed, and then we file it within the receipt that the HRC gives, and then that was done. Then as long as there, the time bar objection was not taken. But the Supreme Court, as of late, and justice, there's a judgment from the Miss Justice Muthu Fernando also to say, because the work is pending. When the HRC the inquiry is pending. So this has now been interpreted in different ways. One, initially, Justice Murthy Fernando and those judgments says, the pending, you make the complaint, you don't know what happens after thereafter. But now the Supreme Court has taken a stance saying, okay, just lodging a complaint would not do. You have to satisfy court that this inquiry is in fact pending, and you have to show proof of that. So, time bar objection, you can, of course, this specific section says that, but the fact that there is an inquiry pending is a burden on the petitioner. It might not be at the time of the support of the application, but might come up in a different situation.
So I believe that reinterpretation or the new approach of the Supreme Court is based on the premise that this HRC provision should not be a way used as a tool to circumvent the time bar. Is it does uh, the usage, whether it's mala fide or bona fide, come into play? Is that where the Supreme Court is now moving towards, in your opinion?
You are putting me in a very bad, very bad wicket. But
No,
anyway,
no, I mean, so
no,
because
no, 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 no,
sometimes
no,
we
no, no,
see.
no, 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 Ashok. I appreciate what you're coming from. I don't think that I don't agree with the Supreme Court's decision on this, the way that they are thinking, because when it is true that people have misused this, when you have a time, we lawyers, I have done it to say, look here, I have no time. They come at the last moment, go and lodge a complaint. We'll file it a week later. I know this, but I don't think that what the Supreme Court is doing in the saying that you have to show that it's pending. When the Human Rights Commission has been established by law, what they do at that in within themselves is, I mean, how can a person be? That is what Justice Murthy Fernando's judgment says. How can you be asked to know what is happening there? How can you show that there is inquiry pending? So I don't agree with it, but that's the law. It is, I mean, there is because whatever the case may be, Supreme Court judgments, none are, all the judgments are non-binding to each other. So some other judgments can come in the future, but whether I agree or not, that's a different issue. But that's how the law stands. You have both judgments in both ways, as you said.
So because I think for practitioners who are freshly trying to file a fundamental rights application, this becomes a very important thing, because I think Supreme Court in one of the judgments where this HRC exception was not allowed was on the ground that HRC application itself, the reason was stated as in order, I'm filing this complaint in order to file an FR application. So I think it is on that ground Supreme Court said, look, this is abuse of process. So I think practitioners should not, in fact, use this. I hope you will agree on that part where
Of
there
course.
is an obvious misabuse of the process.
Yeah.
So coming again back to the. Of course, we will be discussing the substantive usage of the fundamental right jurisdiction, but apart from time bar, what are the other matters a practitioner should follow before or while discussing a matter with regard to fundamental rights application, and what are the requirements they should concentrate before filing such an application?
First thing is that now Constitution recognizes what the fundamental rights are. But as you said, 17 to 126, they only allow us to walk into court when the executive violates this, not the judiciary, not the legislature. Right? So you must know. Sometimes people come and say, look here, the judge violated my fundamental rights by doing this. Let's say someone comes, I was imprisoned or I was not granted bail, my fundamental rights were violated. You can't go. Constitution recognizes it, but you don't provide a remedy for it. So it has to be an executive action, right? In a lighter vein, if you say, some people come and say, in a divorce action, I want to make my mother-in-law a co-defendant because she was the one who decide who was it was because of her that my marriage is over, right? But you can't, right? In the same way, in the same breath, you can't make a judge a party, you can't make the parliament a party, you can't. That happened with the Dr. Bandaranaike's issue, if you can remember. So it has to be an executive action. That is only where you can walk into court and say, my fundamental violator, give me relief, right? Second thing, you have to go within 1 month and you have to file petition and affidavit. Uh, the people who can go is either by yourself, of course, power of attorney can go, or fundamental rights, unlike in the writ jurisdiction, I'm sure that you'll ask me this variation also. Fundamental rights, you can file through an attorney at law, right? An attorney at law can be the petitioner and say, look, I am filing on so and so's behalf. So you have to go 1 month, file it, and you have to ask for, you can ask for just an equitable relief. You find these similar words only in two occasions in Sri Lankan justice system. In the fundamental rights jurisdiction and in the labor tribunal, right? Just an equitable relief. So you can ask for those. You can ask for declarations when what you ask for. If you're asking a decision that to be nullified, you're asking them to make a decision, then a direction from court. Those are the things you can ask. You have to file petition and affidavit. Of course, proxy you have to file. So basically, I think that is what you have to look at if you're a young practitioner looking at a fundamental rights application and you want to be in the practice.
Thank you. Thank you for that very brief but broad introduction on how to file a fundamental rights petition. You are in a very unique position as a practitioner because you practice in the criminal jurisdiction as well as the appellate jurisdiction as well. Fundamental rights, although it's not generally a talking point, has a very close relationship with criminal law of the land. And I mean, Article 13 rights itself, in itself, is about the criminal protecting rights in a criminal matters. So, what is the scope of the fundamental right jurisdiction vis-a-vis the criminal law? And generally, we see in fundamental rights action indictments being challenged, illegal arrest being illegal detention being challenged. Then, above all, police torture. After arrest or illegal detention, we see that torture is interconnected. So, what is the exact scope of the fundamental rights jurisdiction vis-a-vis criminal matters in the land?
Okay, I think that's a very broad
Broad question.
question that you're, yeah, yeah. So criminal, uh, now, one thing is that lawyers should not uh, just think of fundamental rights to say, look here, I am in the Supreme Court, I am doing fundamental rights, and then that only applies to me, right? I think that all lawyers who are, I don't know whether it applies to people, persons who are like mainly focused on civil law, but uh, persons who are involved with criminal law, of course, whether you come to the Supreme Court yourself or not, it's that the fact that there is such a jurisdiction is very important there. Starting from the point that a person is arrested, whether that person is tortured, the right of the lawyer to represent that person, right? Uh, in court, in police stations, all that comes under the right to be represented and Article 13, which is there in the Constitution. You have right to be not to be tortured, right? That is Article 11. In Article 13, your right to be represented, right? Be heard, so on and so forth. So the practitioners of criminal law should be aware of this. Whether that you yourself come to court or not, you should know that this jurisdiction is available. And I think that this is one. Now, we know, right? When AG's department, when we make these complaints, the AG's department, the court also knows that police assaults people, right? So Sudha knew this long time ago, right? That is why he said, don't admit the statements made to the police. He said this because you know that you torture that person and get him to say sign anything, right? You know this. Me, I know it, judge knows it, the ages department, everybody knows it. So the fact that the police assaults might not be in Colombo, but in when you go to the outstation, the rural area, this happens, right? So the how to tackle that is one way knowing that look, if you do this, this jurisdiction is available. You have a right to be represented, right? If you are taken into custody, you have the right to be told. I can go through the section. I have it in my front of me. I don't want to read because we are talking to lawyers. But why you are arrested? You have a right to be represented by a lawyer. All that is there in the Constitution. If that is not allowed, then you can go to court. And also, one thing is that this is our profession. Is the only profession which is recognized by the Constitution. Doctors are not there, engineers are not there, but Constitution recognizes attorney at law, rightly or wrongly, right? So, so the lawyer who is not allowed to represent a person. Now, why if a person is to be arrested or you go to court, so go to the police station and you're not allowed to visit that. I am my very liberal view is that if you're not allowed, you are violating or infringing the rights of the lawyer also. Because Article 14.1 says, 14 says that the right, freedom to engage in your profession. That is also being infringed. So That it's a very broad area, but criminal lawyers should know that they have this right, right, where you can resort to if you are not allowed to do your job properly, and if your clients are being victimized in certain way.
Recently, also we saw an attorney at law had filed a fundamental rights action on the same manner where he was not allowed and he was demeaned by the police, where he endeavored to appear for his client. But on the same note, now there is, although this is theoretical, but I think now since you mentioned it, there are two sides. One is where our evidence law does not directly admit a confession or statement made to the police. And on the other hand, we are also now, I believe the IGP has also issued a gazette allowing attorneys at law to represent the client.
Circular.
Circular. So if the attorneys at law are representing, like say in the US system, uh, in the police interrogation, then should not then those statements where an attorney, where a person being interrogated in the presence of his attorney with his assistants making a statement, should not then that be admitted? So isn't this debate is also involved in that? So that this whole question is a question of for further legal reform. I mean, I was only curious when these two matters were mentioned, so that is why I am just diverging into this.
Yeah. Now we are venturing into something which is not fundamental rights. But Ashok, since you asked, I think in the long run, I'm 100% in agreement with you, because if you say that, so then you know that US you have the Miranda rights. You say
Yes.
you have a right. Moment you are arrested, you are told you have a right to an attorney.
Yes.
You have right to be. If you do that, not that you arrest him, you assault him, and say, okay, if you don't do this, then you bring an attorney. Sometimes when you go to the magistrate's court, the attorneys are also police, go and retain so and so. Not that attorneys. But if you do the Miranda and then say, arrest, you have the right to an attorney. Before that, you don't interrogate him, give him that right. Yes. But I don't think we have developed into that. But let's not venture into that because
Yes.
it's not fundamental right.
So coming back to criminal justice and all, we see certain instances, especially as you mentioned, outstation. We've heard that people get arrested. So as soon as possible, they have to be produced. But sometimes police arrests, keeps them maybe overnight, and then releases them without consequences. And then at that point, torture also happens. And of course, they are threatened. The people who are arrested, they are threatened not to go and or take any action. So, in these circumstances, what do you think a lawyer can advise those clients? Because this is something mostly young practitioners come across these kind of situations where they are arrested, kept overnight, and sometimes tortured and released. So these are situations they face.
Yeah, no, you can't. First thing is that you can't do it, right? If you're arrested, the moment you are arrested, then that must be in the sense like they call it produce karla. The police says it's produced. That is, you have to enter. We arrested so and so on such a date. If you want to release him after investigation within 24 hours, you have to. But the police says it's a report. They file an A report and says we have arrested him so on such and such a day yesterday, but we don't find him to have done anything, and then produce him to court and release. Right? Moment you arrest, that is the procedure forward. But torturing, of course, only thing that we can do other than for administrative relief, in the sense, of course, we know if the OIC or that police, let's say, your lower rank officer assaults a person, then you can obviously go to the OIC. If the OIC also is not acting, go to the ASP, SSP, DIG, so on and so forth. That is administrative part of it. But other than that, then either HRC or the Supreme Court.
So Another issue that comes is when someone's filing an action, say for illegal arrest or detention or worse, torture. There will be a petition and there will be an affidavit. But sometimes the court expects, especially in the event of torture, MLR, medical legal reports, and so on. So, what are the documentation, supporting documents and evidences generally is advisable in an FR application with regard to, say, detention and torture, illegal detention and torture?
Yeah, detention and torture Supreme Court have through over and over again said that it's a bit of a higher burden than Article 12 want to say, unequality to because torture or assault, it's criminal in nature and then it ventures into the criminal justice system where generally a trial is taken up. Now, you can look at a person who has been tortured, but on the other hand, there is an accused who might be let's say, a police officer. Then he does on affidavits, can you be found fault with? And that on his part, let's say he might have 30 years in the police department just because someone comes and say, files affidavit, three people, other kid, I saw this person being assaulted. Can that person be, you know, stripped of all his ranks and so on and so forth. So our judges have always said we are going to rely. If torture is I appeared in a case where Justice Kodagura says, no, Mr. Devendra, you know that this is a bit of a higher burden. I said, yes, right? So one thing is medical reports, right? That is one of the most important things that judges look at. If you can show that, look here, before me, I was arrested. When you are produced, because when you are produced, in the sense like when you are arrested in a police station, the reserve police, that Ralhami who takes it down, says, okay, he has this scar, his arm is not working, he's bleeding or whatever, he takes it down, right? So on the next day, when he's produced to court, if he's bleeding and he has scars, right? Then that is one. If you don't have medical, but then if you are like put into the remand prison, then the remand, when they are taking down, they will say, no, he has a hole in his head or whatever, right? He has this. Then if you are put to the prison, remand prison, there will be medical records, right? When you go to the magistrate, now let's say you are afraid to say anything at the police station, you are produced by magistrate court through your lawyer or by yourself, that person can say, look, I was assaulted. The magistrate will record it, and say, okay, prison authorities, examine me. So, torture, higher burden on the part of the petitioner, but of course, you have to show if there is no medical records, it's very unlikely that the Supreme Court will hold with you, right? But I did a case, I actually took my laptop and showed it to the court, where the petitioner had a problem with another police officer who was going out or who was going out from the police station. He had video recordings where he went to because he had issue with the police. He went to the hospital. He and another person, and then he was dragged out from the hospital. So he had video recordings. So those are also records which you can make a use of.
Thank you. I think that's very useful in order to establish your case, because that is something important for any practitioner coming before the Supreme Court. If we move a little bit further, since we are also having very limited time and the scope of fundamental rights is so wide, now there are fundamental right cases filed challenging abuse of discretion of government officials who make decisions. For example, say in the matter of land, there's plethora of cases, specifically outside Colombo as well as Colombo, but mostly outside Colombo, with regard to land permits and grants and successions within that and so on. how do you think the fundamental rights jurisdiction, in addition to writ, is utilized in these matters where officials by law are given certain powers and discretions, and where someone is aggrieved by a decision? How is fundamental rights useful in those circumstances?
Yeah. Now, in land matters, for one reason or another, since it's more procedural, this land development ordinance, ground land ordinance, so on and so forth, uh, Ashok, now we go to the writ court more often than not, rather than coming to the Supreme Court. But any administrative decision, now, uh, unfortunately, we still hear this that this discretion. The moment you say discretion, sometimes the state comes and argues. So if you have a discretion, we can decide one way or another. Even though there is a plethora of judgments to say that that discretion is not like you can't, not on your whims and fancies. We still hear, you and I know, still they come and say, look, discretion, no, we decided in this way, right? We hear this, right? Unfortunately, the Honorable Attorney General's officers also come and say this. But discretion, the moment the discretion is given, that is where you have to be the most careful, right? That discretion has to be exercised not arbitrarily. It has to be legal. It has to be by the person who does it, not by someone else. It can be the person who has the authority. Let's say if the person is the Grama Sevaka. Grama Sevaka has to give some, let's say, to cut down some trees, the Grama Sevaka can give the certificate to say, cut down the jack tree. The divisional secretary can be superior in hierarchy, but the divisional secretary can't do it. It has to be the Grama Sevaka. You are with me?
Yeah.
So right, so that discretion can't be arbitrary. It has the wide. You can't usurpate the power. You can't abdicate the power. That must be done by that person, and you have to be very careful. And then you must, of course, the principles of natural justice. You have, if someone is complaining, then you have to hear all the parties and come to a decision. And that can't be an ad hoc decision. That has to be a decision taken objectively. It can't be subjective. You can't be your own judge. If you know that person, you must recuse yourself and say, look, here, I can't make that decision. Pass it on to someone. All those are there. Whether it, no, I think the reason that you brought the land development ordinance, whether it's applicable to FRO or not, is because of the fact that when the person who are holding the ownership or the grant dies, there is a devolution process and
Yes.
the divisional secretary has to decide. And then we know that divisional secretary sometimes go and do certain things which are not according to law. So that can be challenged, right? Not only that, any decision. So that's a very simplistic issue, but I think you hit the nail on the head when you spoke about it, because that's the way that our viewers can understand. But any decision you take, so for example, let's say the governor or the chief minister of a province is given certain amount of money, or a minister is given certain money to do build a road. He has, let's say, 100 million rupees to build roads. And if he chooses to build the road, not the most productive one, but the one which leads to his hometown or his electorate, then that can be challenged. So
So,
discretion can't be used in such a way which benefits you, but it must be because at the end of the day, I think we missed that, Ashok. At the end of the day, all the powers, the Supreme Court judges, the judiciary, the executive, the legislature, the sovereignty is with the people, and they are holding all positions in trust for us.
yes. So when we say that, when we speak of all these abuse of discretion cases, the fundamental rights clause in the or article in the Constitution that becomes relevant is 12.1, equal protection of law. Now, 12.1 seems to be the most versatile fundamental right guaranteed under our Constitution. And that is used from an LDO case to even in the case of marine pollution to economic crisis to inaction in defense matters. So we'll discuss that. But today, the talk of the town to a certain extent, at least a certain part of the country, is about this has always been the case whenever there is a governmental change. A hot topic is political victimization. There had been commissions appointed to inquire into it, to do justice in the past. And of course, a lot of FR applications are filed. So when it comes to political victimization, how can FR jurisdiction be a tool to vindicate the rights?
Just can I deviate from your question a bit to
Of
come to
course,
the
see,
substantive rights and then come to
yes.
Article 12.1? Now, for anybody who's going to be a practitioner, when you start the substantive rights of fundamental rights from Article 10, right, where you have the freedom of thought, conscience and religion, then torture, 12, one that I'll get back to because it's like the omnibus clause, 13, criminal justice, 14, other freedoms, right? The 15, you come with the restrictions, so on and so forth. Now, Article 12.1 is what you call the omnibus article. I think Ashok will, you being from, you be a student from England, I think you can explain what this omnibus clause is. Yeah?
Very well, but I think the viewers will love to hear it from
No, no, no.
you,
That
Dave.
is where you say that everything is taken into right encapsulated into that. So Article 12.1 is inequality. Initially, it was like X and Y. You can't treat X in a particular way. So Article 12.1 has two folds: the negative aspect and the positive aspect. Positive aspect is you can't have someone being treated negatively than the lesser than the other person. Positive aspect is you are the other way around. Now, Article 12.1, whatever. Now, I have never, I have, in my experience, I have never seen a situation where court have felt that you have violated this article, but not 12.1. Every fundamental rights application I have seen has 12.1 in it. If you are tortured, 12.1. If you are like, access to lawyer, 12.1. So 12.1 is there. So the question that you posed was political victimization. Now that is a huge issue in Sri Lanka because the moment everything is politicized, then there is political victimization. If 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 appointments are political, then there is political victimization. One can argue, yeah. So if it can start from the highest office to the secretary, to the president, which the administration considers to be the top post, right? To the Gram Assembly, right? From judicial officers to the chief justice to the first appointee to the judiciary, from the AG to the state council. These are all political appointments, in a sense, right? Now we have a bit of a check and balance with the Constitutional Council, but that also, if the ruling party, as we have today, is has the majority, then of course, then it's political. So what happens is the moment the ruling party changes, then people come and say, look, yeah, I didn't get this promotion because of political victimization, and they come and complain. And then the governments, because these are people who are affiliated to them, have had these commissions, and though most of the recommendations which have happened recently have been quashed by the Supreme Court or the Court of Appeal. But that inequality comes in this way. The recent judgments of the Court of Appeal, Supreme Court, if we are talking about the Supreme Court FR jurisdiction, is that unless it is under some procedure. If someone can show, look, this is the SORP, the the scheme of
Scheme of
promotion and
recruitment or promotion.
yeah.
Yeah.
Then if you can show that that is why I have not been promoted, that is fine. But if someone comes and the some commission says this is political victimization and because of that I was not given, that will not suffice. That has been the present Chief Justice, I think, well, with his the police, there are cases which are coming up next for 14th also, all these police promotion cases where these political victimization have been questioned. And that I think at the moment, for a practitioner who's looking at practicing in the Supreme Court at this moment, that is what the Supreme Court stands. Where that is where they stand. They not just to say, look here, I was politically victimized, I am this, not that. But if you can show, if there someone can show, like I was victimized, this is a SORP, I was not given the promotion because of this, then other than that, that argument will not hold water.
Thank you. And the viewers, if you all have any questions, feel free to send your questions so that we can discuss and esteemed panelists can endeavor to answer them and clear your doubts during the Q&A session. So my next question, when we speak of governmental power and abuse of discretion, there's always this interesting question of policy. Now, generally, mostly in the UK or in other states, or generally where the common law is practiced, it's always said that there is expected a judicial restraint from the judiciary when it matters, when it is asked to adjudicate on matters of policy, because policy comes within the exclusive uh, purview of the legislature and mainly the executive. So, when in policy matters, is it possible to challenge them under the fundamental rights jurisdiction? Because we see in few recent judgments on hindsight to a certain extent, adjudication on policy, bad policy, or terrible policy, or policy with very severe consequences have been held to have violated to one rights of the citizenry. So, in matters of policy, where can we draw a line in filing fundamental rights application?
Yeah, Ashok, it's like this. The Constitution per se has not restricted the judiciary from visiting or going into policy decisions. It has come from the the English law, where they have said, look, now, I will take a simple example. I think for the viewers, it will be simpler. We file cases where school admissions are not being challenged. Your child is not taken, right? So that's a very simple question. But if one were to look at and say that this is the way that you should run a particular school, the judiciary can't do it. They don't have the expertise. But if you can pinpoint and say this is where you have gone wrong, of course you can do it. So policy, the judiciary does not have that expertise. They are doing an adversarial role where two parties come and say this and that, and they have to give a decision. So, on a point, of course, they can do it. If it's a promotion, torture, on that point, doing it. But policy, for example, let's say fiscal policy, taxation, excise duty, right? So, let's say you decide to impose a tax of 100 rupees for a bottle of arak, right? It's not just you just, you know, take that number and put it. You look at how the excise officers work, what they have to do, and you look at it and put it. How can the Supreme Court, sitting in that court, decide on this? Right? So, policy is something that the judiciary has always been very reluctant to step into. But They can, and they have. This the economic crisis, they have. The emergency regulations, they have, right? But it's very easy, as you I think you hit the nail on the head when you use the word in hindsight. When it goes wrong, it's always easier for the judiciary to say, look here, this is the policy you made, and then that has now backfired, right? But the problem in my mind is where you make the decision to take that policy. Has our Supreme Court stepped in and say, look here, we have to stop this? For example, I can give you an example. The Sri Lankan government at one point decided not to allow burial of people during the COVID-19 pandemic. That was a policy decision, which was challenged, right? I'm not saying it is right or wrong, but Supreme Court said that was right. Why? Probably Supreme Court, with the material which was available to them, right, decided, that was the right decision. But we now know it was not the right decision. I mean, I'm not blaming the Supreme Court, but other than China at that time, every other country allowed, and we now know there was no issue with that. But Supreme Court has to go by what is presented to them, isn't it? So policy is a very, very sensitive topic, and the judiciary has always been very cautious. They have given judgments and judgments to say that we can step into it. Even the Red Court, the Court of will have said it, but they have been very cautious and mindful, right? Not to step into the shoes of the executive when they are doing it, because the executive, whether Sri Lankan executive does that, I don't know, but have to go through a lot of hoops to make that policy, right? So unless you can pinpoint and say that this is where you have gone wrong, the legislature, sorry, the judiciary will not step into it.
Yeah, very correct, because it's a very difficult area to adjudicate. Now, for example, if we go back in history, when the 1970 government came into power, they came with a clear mandate to socialist mandate, and also uh, a decision to close down our economy. And history says, I mean, I was not living then, I was not even born, but history says that people had to stay in queues. There was scarcity of food. People had to eat. I mean, they couldn't eat grains, rice. There was a lot of scarcity. So but that was a decision, a mandate by the majority voters given. They made a choice. So, if in future the mandate is to say establish a communist state, a closed economy, no imports, and there is scarcity and suffering, could the judiciary, through fundamental rights jurisdiction, enter and find fault with the executive and the legislature, which actually is implementing the mandate? So, where does that line gets drawn?
No. We have now moved. I think we have developed our law, and the world also have developed, and I don't think that they will just go and say, okay, we are going to have a communist state or a socialist state. That will not happen. I hope fully that won't happen.
No, that was
But
a simply
no, 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 no. I
simplified
know, I know, I
example,
know.
but I say if a
Yeah,
decision
yeah, no,
like
no,
that
no,
is
no, no,
taken.
no. But we can challenge policy if a person, if fight. So the extreme example that you take, so they come and say, okay, we are going to close down. We are not going to import rice or import saris or whatever. And then if we can show that that is not mandated or that was arbitrary, right? The Supreme Court can venture into that policy decision and say, quash that policy decision, right? I think we have evolved to that extent, and the executive is also aware of that fact, right? If the executive, because executive and the legislature, they are always looking at re-election, right? The most humiliating thing for them is to take a decision like a huge decision like what you said, and then to be quashed out, right? Struck down by the judiciary. So that the fact that they have that consciousness is enough, I think, for us to be secured enough. But the Supreme Court, of course, any decision that they take that can be policy or otherwise can be struck down.
I think on that light, we have to also discuss about the new scope that got opened up after the 19th Amendment, and it got paused for a while and then continues again now after the 21st Amendment, is where the ability to challenge president's actions, except declaring war and peace, under the fundamental rights jurisdiction. Uh, of course, the Constitution mandates that the FR application must be made against the Attorney General, but nevertheless, the President's actions and, of course, inactions can now be challenged. How do you see this new development, and do you think it has made the government machinery more effective, or it has pulled back the effectiveness of executive discretion?
Okay, that's a very difficult question to answer, Ashok, because we have a very the Sri Lankan system is a very I think is a, for want of a better choice of words, is a very bad system, right? Because we had the Westminster system, and then we interpolated the president into it, right? Now, for example, if you take the American system or the German system where you have a chancellor, the French system, you keep the executive out of the legislature. The American system, you have the foreign secretary and so on and so forth. The executive is out of the legislature. When Donald Trump comes, he brings in all his 17 people. They are not in the parliament. They are not in the House of, they are not congressmen. They are not in the Senate. They are out. Where we have a system, you have a president who is all powerful, and then you have the ministers who are in the parliament. They are also powerful, right? So we have a very, see, the system that we have with the 1970 constitution, I actually, personally, I don't like it. So your question, answering your question is, now, has it, so from the moment it was introduced in 1978, every government that has come, right? I don't think Mr. Ranasinghe Premadas said it, but starting from Jasika Chandrika, Mrs. Chandrika Bandaranayak Kumartunga, Her Excellency, everyone is saying, look here, abolish the presidential system or dilute the powers. And finally, Maithripala Sirisena and his government did it because that was that is how they won the votes. I think I have no issue. I think what has been done with the 19th Amendment, the fact that you can challenge the president's decisions, right? Because we, the president has this executive power. Let him be held responsible. What's wrong with that? I mean, if someone is taking, if a Grama Sevaka, divisional secretary, is taking a decision and he is accountable, why can't the highest office be responsible? Right? But the other argument is this, right? If I may say this in a lighter way, right? Though in those kings' days, you had the several Bisavas, no? You had the Antapuri or concubines. Why? Because you didn't want the king to be, worried about anything else. You had to make him happy, and then you had to have that free will to do something. If he was to, if the king or the president, I'm talking from the other point of view, when the president is taking a decision, now you're giving the power to say, you have a separate election, you appoint the president, you give him the hand, you are the, you know, the commander of the armed forces, And then when he's taking a decision, I'm not talking about war and peace, but any other decision, let's say appointing at the, now, for example, now today, if he appoints the commander of the army, that decision can be challenged, right? So if he is to rethink everything, can he do a proper job? So that is the counter argument. So I will leave it at that. I will not give you a conclusion, but my point is that it is okay. Because I think the Supreme Court also is conscious of that fact. That we will not, every time a president does something, we are not going to venture into it, unless you can pinpoint and say that this decision is so bad that it ought not to have been taken. Then the Supreme Court also, I mean, we are looking at the Supreme Court as no more superior than us.
So before we move ahead to the question and answer session, I have a final question, initial bunch of question. Is that now that we discussed about the scope of fundamental rights jurisdiction, how an action can be filed and what the young practitioners especially have to be aware of in utilizing this jurisdiction. However, there is always another side to the coin. That is, as a attorney at law, as a practitioner, uh, the practitioners have certain responsibilities to the court as well as their clients. So this is a very important aspect, and I believe our Supreme Court has repeatedly insisted, and also very recently we see a lot of rule matters. Supreme Court highlights these issues pertaining to attorneys' responsibilities. Now, I do have specific questions, but before that, what do you think are the responsibilities of attorneys who are approaching generally court and more specifically in these fundamental rights jurisdiction, as the scope here is so wide and a lot of people we see filing public interest litigation, so on and so forth. So what are the responsibilities of attorneys at law in approaching the fundamental rights jurisdiction directly to the Supreme Court of this country?
It's like this, Ashok. Anyway, any court. I think sometimes attorneys, seniors as well as juniors, are taking lightly the responsibility that they are given, right? Irrespective of whatever. But since we are looking at the fundamental rights jurisdiction, let's not uh, you know go into the other courts. But if you are a junior lawyer, especially if you are an instructing attorney, you appear in court, you should know that you are before the highest court of the country. You should be, I'm not saying be afraid of the judges, but be afraid of the system. You know that you are a cog in that wheel, and that know when you have to do whatever, study to the brief. It might be a calling date, get ready and go. If you have to file a motion, give notices, whatever, don't come and say you have no instructions, right? This reason, the present Supreme Court is very aware of that fact. So, whatever you do, especially if you're complaining of a fundamental rights violation of a client, don't get that matter dismissed, or don't get the court to not like that case, because you have done something wrong. So always be cautious, and always, I mean, you have to do it any court. I mean, it doesn't have to be the Supreme Court, even the magistrate court. You have to. The other day I was in, I'm not going to tell the court. I saw two lawyers who were the most senior two lawyers in that court. One had an iPod in her ear. The other one had the first one who was treated to the most nearest to the magistrate had the hand free, and both of them were answering and taking calls. Right? So you can't have, and I know in the Supreme Court, the State Counsel, the DST who was opposed to me, had gone and told a lawyer, a very senior person, in the sense at least he was old, gone and said, look, phone ගන්න එපා. And then he had like looked at her like, who the hell are you to tell me? So, I mean, you have to be cogent, you have to do your part, and fundamental rights, if you are doing it, just don't do it for the sake of doing it, right? You know what you are looking at, infringement, imminent infringement, continuous infringement, whatever. Then what you are asking for, know whether the relief can be granted, right? So all that you have to know, and then only that you should move into and invoke the jurisdiction.
Thank you for sharing those experiences as well. And I think that will be useful to identify incidents that sometimes someone might not even think that this is bad or we should not do this. But in fact, that needs to be clarified in some forum, and I think this would be a ideal place for that. So we have one question. We have received the question now, which is with regard to the uh, challenging the president's actions or inactions in an FR application. It says now, generally in an FR application, you have to make the Attorney General a party. When you challenge the president, instead of naming the president, the Constitution mandates you to name the Attorney General in lieu of the president. So, should you make the Attorney General twice as the respondent? Because I think this question comes in the light of now certain practitioners preferring to add two respondents, AG twice, one in lieu of the president and another attorney general in his capacity of attorney general. Is that necessary? I think it's a question of style and form of the petition.
Yeah. So no, it's like this. Before the 19th Amendment, anyway, when the president, now it's only after 19th Amendment that the president can't, 20th Amendment it was stayed, but 20th Amendment it came back in. Now the president, after the 19th Amendment, before the 19th Amendment, if the president so acted in the capacity of a minister, let's say he acted in the capacity of the capacity of the Minister of Defense, that could be challenged. Initial before the 19th Amendment also that could be challenged, and then you have to make the AG a party. Anyway, fundamental rights jurisdiction, AG always has a right to be heard under Article 134. He has to be named. You don't have to name him twice. Once is enough. But if you want, once is enough. But out of abundance of caution, if you want, you can name him under Article. You say, I'm making the AG a party under Article 134 and also under Article 34. 134 and 134. That is suffice. But anyway, if you say that AG, but on behalf of the president, that will suffice.
Now we have another question. The question reads, how do you identify whether to go to the Supreme Court for fundamental rights violation or to the writ court when the matter is regarding an appointment or promotion? How do you identify between administrative decision and infringement of rights?
Yeah. Fundamental rights jurisdiction is actually a wider area, because you can look, it can be in a way that it can be on so for example, it can be on sympathetic grounds, because if you are looking at just and equitable relief and you are looking at inequality, so on and so forth. But the writ court is very focused, and it's a procedural issue, if I may put it in that way. If it's illegal, if you can show that this decision was taken illegally, then writ court is better. If you can show that it's the procedure was not followed, writ court is better. If this it is arbitrary, you can per se show that this is arbitrary per se as to this decision, writ court is better. But of course, right? From a practitioner's point of view, Ashok, you and I know when the when 301 judges are lenient, we file writs. When then the Supreme Court is much more lenient, we go and file fundamental rights application, but we switch from one to another. But I think the writ court is more to procedure. where you can show it's not on to sympathy, but on procedure. But the Supreme Court looks at a wider area in respect of, as you said, Article 12, where inequality, and a broader, it has a broader perspective to the report, if I may say that.
Thanks. We have another question waiting. That is, what are the special types of relief one has to seek in FR matters? Can you please give some examples?
Okay. So now, one thing is, like, for example, if you are tortured, or the action is done which is irreversible, whatever it is, torture, or you are, expelled and now you're retired, or whatever decision that is taken, now you can't take it back. Then, of course, what you can ask from the Supreme Court is, give me damages or compensation, and uh, punish them, in the sense, like, not penally punish them, but do it for, but for torture, right? Uh, you can give them compensation. So if, let's say, I'm tortured, compensation, and the Supreme Court has time and time again have given decisions to say, or the prosecute them, given directions to the Honorable Attorney General to prosecute them under the Torture Act and the Penal Code. You can ask for that, right? So, and if it is a indecision or a decision that they are not taking, for example, you are asking for some, let's say, for promotion, to be for an appointment, and so on and so forth, you can ask the Supreme Court to make that decision, direct that person to give that promotion or an appointment, and so. So it is, if it's a decision which has been taken, you want to be set aside, that can be done by the Supreme Court. If it's an indecision or a non-decision, or not giving the decision what you want, you can ask the Supreme Court to do it. And of course, financially, you can be compensated. And if there is, like, something criminal in nature, like torture also, you can get the Supreme Court to give a decision directing the Attorney General. Now, generally, Attorney General decides, but you can give a decision to Attorney General to prosecute him. That can be done.
Thank you. So I think there's another question. It actually relates to the previous question on the connection between writ and FR. Like the writ jurisdiction, does the FR jurisdiction have technical limitations, like you have to name all the necessary parties, etc.?
Of course. Uh, the necessary, in the sense, it's like this. Uh, the, 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 the necessary party thing, there is a judgment, which is I was also a junior in that case, by Justice Amaratunga. Uh, I remember this case because the name Dr. Nishanta Nanayakara versus Kyuko Kuma, right? It's reported. It was actually a special leave to appeal. It was in the Court of Appeal. But the Justice Amaratunga speaks about necessary parties. I think it doesn't differ from the Court of Appeal to the Supreme Court. Same thing. Only thing is, Supreme Court, AG must be name a party, and it has to be heard even at the time of leave, right? Leave to proceed. Uh, the basic thing is, you have to name, if you are asking for a decision to be set aside or quashed, or it is either way, either you are asking for a decision to be quashed, or an action which has been done to be called wrong, that, or someone who is not taking an action which you want. So that party, the decision maker, or the person who tortured, that person, the administrative body, a person must be made a party. That's simple, no? Right? You can't go and make the IG a party and say, look, OIC of Angudukola Palace assaulted me, and not name him a party and make the IG a party. IGP a party. Right? So you have to make that person a party. Right? By name, or if you know him by name, you have to make him by name. If you are asking a particular land to be devolved upon you, and the divisional secretary, so on and so on, you have to name that person as the divisional secretary. The divisional secretary come to pay. And if a person is affected by the relief that you are seeking, now that person might, for example, the divisional secretary has given the property, the ownership of a land which was with your father to your brother. Now you have walked into court by way of writ or FR and asking, no, no, this is wrong. It ought have to come to me because I am the eldest son, right? So the sister to whom that land has now been given must be made a part, even though that person has not done anything wrong. So these are the people whom you have to bring into court. The decision maker or the indecision maker, the person whom will be affected by a decision that you are asking, and the AG. These three people.
I think we have received a follow-up question on that point is where you do not know the name or address of the person who had I think this is in the context. The example given is in the context of a torture case where you don't know the name or the address of the officers who tortured you. How do you make them a party in an FR application?
Yeah. If you know even a part of their name, let's say you know his Sergeant Ranjit, then you can say Sergeant Ranjit. That is what we do as practitioners. But if you don't know, in the body of the petition, you can say, look, I don't know these people. There were 4 people who assaulted me, or I don't know, I was blindfolded. There were several people who were this thing. Because if the court, in fact, gives leave to proceed, and when the notes come, they will have the people, the notes will say, "Well, this is the person who arrested me, this person, so on and so forth." So you can always reserve your right to add people at a further time. That is the only thing that you can do. I mean, if you don't know, you don't know, right? You make the OIC a party. Since you asked that, Ashok, now OIC always has a vicarious liability. That has been held over and over again. Let's say OIC was not even there, but someone assaulted you, the officer in charge will always have a vicarious liability on the on an assault or a violation of your fundamental right. So even if you bring in the OIC and then say, okay, I was assaulted at this police station by several people, I didn't know, but look at my medical records, I have in fact been assaulted, then you can, even at least the state can be made liable.
Thank you. I think we have received another question, although uh, it is not, it's a bit vague at some point, but the question is if an administrative body has done an illegal act, can a petitioner challenge it, even if the petitioner has benefited from it?
No, no. Okay. Can an administrative decision be challenged even if the petitioner? That's like saying, you got your way with a girl who was drunk at a party and then say women should not drink, right? I will say no.
That's a very interesting question. But now that adding to these administrative decisions, most of those instances we see administrative
No, no, no,
decisions.
no, 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 no. I think, no, no. I think that was what sort of a rhetorical question. If you have benefited from a particular administrative decision, can you later come and challenge it, saying that it ought not to be? There is nothing to say no. There is nothing to say no, no. I mean, for example,
Correct.
there is not, if that decision is wrong, uh, uh, that if that decision is wrong, you can, right? So I think we will move with that. We will come into this issue, Ashok. Now there are two ways that FR jurisdiction is exercised. One thing is where you come and say, look, my fundamental rights are violated. I think we did not. I think it was a mistake on my part. And the other is public interest litigation, where go and say, okay, there was nothing wrong done to me, but in the interest of public, this is wrong. So I think the viewer or the person who asked the question would have been actually venturing into that to say, look, I would have benefited from this, but that is wrong.
But it's
It's not. So I am. Why he might that person might even enjoy that benefit, but then come and say, look, in the public interest, in the eyes of the law, it ought not to be the decision and challenge it. So you can, but I have very I am waiting to see such a day. I have not seen it.
So in that light, challenging administrative law questions, especially administrative decisions, most of them are taken by the cabinet. So in that instance, should one name the whole cabinet as
Yes,
respondents?
yes, yes, yes. If you are challenging a decision of the cabinet, that is one of the reasons when you are challenging a cabinet decision where you can't go into the court of appeal. Why? Because the president is a member of the cabinet. You in the court of appeal you can't, so you have to come to the Supreme Court, right? Uh, I think that was changed. I don't know. There is some vision anyway. Anyway, so the cabinet, you have to name the entire cabinet, and it's appropriate. Of course, it's easier if you name the secretary of the cabinet also, but the cabinet, all the cabinet members must be brought in.
Uh, so I think we are at the latter point of this interesting discussion on the basic law and fundamental rights. And I think it will be appropriate at this point to hear some closing remarks from you on things which you think would have we should have discussed, or some closing remarks on the point summarizing the matters we have discussed thus far.
Uh, fun. Okay. No, no, no. If I we spoke about Tashuk, I think the procedural aspect of it. One thing I think we did not discuss was the not the procedure per se, but the how to the how to invoke the jurisdiction. But I think the practitioners will like to know, as a civil procedure and the criminal procedure code, the Supreme Court rules apply for fundamental rights applications. I think we didn't look at it. So, if the Supreme Court rules is the procedure which governs everything, where you have to file, what are the documents to file, the affidavits of format, and so on and so forth, is there in the Supreme Court, the rule that is there. And 1 month rule we spoke about, the jurisdiction, the policy. I think we basically,
If I may
ha,
interject, I think
yeah,
one
yeah.
aspect
Sorry,
is
sorry.
interim relief.
Yeah, I think, yeah, I will come to interim relief, and also there is this one other aspect. Now, substantive fundamental rights are in Article 10 to 14, and 15 is the restriction on fundamental rights, which I think we will not go get into now, but where other than certain rights that torture and then though the 12.2, that certain rights can be restricted for certain situations. So that also some must be known, and the viewers must know. And also your question that interim relief, of course you can ask for interim relief uh, if the infringement is imminent, and that there is going to be some irreparable damage, that it's similar to the principles apply which in the civil code, in the district court applies. You have a prima facie case, release that Bandaranayaga judgment, so things happen. So you can walk into the Supreme Court, give notice to the AG, even without notice. Technically, it is possible, but nowadays you have to give notice and support for interim relief, and ask that the issue to be whatever problem to be the decision to be stayed. Like, for example, someone is to be arrested today, and then that person don't want to be arrested, and it is illegal. You can go to the Supreme Court and ask not to be arrested. If you, let's say, a building is to be brought down, you can go to the Supreme Court and say don't break it down. That possibility is there.
On that note, I think we'd also like to know when you are filing and seeking an interim relief. there becomes another procedure, which I believe is generally practice of limited objections and limited counter, and the time that is consumed for that. So I think that is an additional procedure, more of a cursus cure procedure that is practiced. I think that would also help young practitioners coming into FR jurisdiction.
Uh, I look. It's the thing. This is the thing. Now, with the workload of the court, we have to look at it. Whether I like this procedure or not is a different issue. But I will address I will give you my Satadeka on that also. But the thing is, the Supreme Court with their workload, without the material available from the other party, sometimes are reluctant. Otherwise, unless it's like, it is hitting in between the, you know, it's like so in your face. They are very reluctant. I mean, you give an interim relief, might turn into a final relief, so they are reluctant. But there is no necessity, and also I said that the procedure is the Supreme Court rules, right? And at the time you have to give notice, then the AG will be represented. And if you're asking for interim relief, of course, the other parties also must be given notice. But even without notice, you can ask for interim relief, and the Supreme Court has ample power to give you interim relief without this limited objection and so on and so forth. Because when you file a case, if there is some infringement which is going to be imminent, then you go through the whole process of this. You file the case, you can't sometimes even get the matter to be supported. You get that in 2 months, 1 month, and then limited objection, limited counters, then support. I don't think the concept of this interim relief makes any sense if that is the case.
That's a very interesting perspective into it, and I think again we have to approach the whole question on just and equitable jurisdiction, the light of the fact that this is just and equitable jurisdiction. So I think we are at the latter part. We are nearing an end of a very interesting discussion, and I think I am willing to hear your closing remarks. Any final words on today's basics of law, fundamental rights session?
I think we've covered everything, Ashok. As far as the fundamental rights jurisdiction, I want it to expand. We've got to venture into areas like environmental law, which like India is like far ahead of us. They have green courts and constitutional law. I don't think we have advanced ourselves to that. And also, the public interest litigation was very much alive some time ago in Sri Lanka also. But I don't think that we are there now. And the lawyers also have to, I think, be more proactive, and we have to look into other jurisdictions. Uh, Constitutional wise, we are okay. And I think we have basically covered now. For example, we don't have the right to life in Sri Lankan law. But authority says
Yes.
Srirani versus Malgoda, we have it, right? Article 12 have it. So Article 13 has it. So I mean, law as it's stipulated, I think we are okay. I don't think that we are in a state to go further. But jurisprudential view, I think we have to revolve a bit more. That will be my closing remarks.
Thank you for that great discussion. It was a pleasure to moderate. Although in certain aspect I would have had a different opinion, but being a moderator, it was very interesting to hear this discussion. Isuri, now it's to you.
Thanks, Ashutosh.
Thank you, Mr. Ashok Baran. This brings us to the end of the second webinar of the series on basics of law titled Fundamental Rights. I thank our esteemed panelists, Mr. Astika Devendra, and our moderator, Mr. N.K. Ashok Baran, for the fruitful and educational discussion and for dedicating your time to be here with us and sharing your insights. I thank the BSF Webinars and Legal Symposiums Committee for their dedication and hard work in organizing this insightful webinar. And last but not least, I thank all of you who have joined in for this session today through various platforms, interactive discussion that we've had. Thank you, and I hope you all have a very good night.
Thank you.
Thank you.